I'm not sure. I got some, unfortunately, the way that evidence is distributed now, it doesn't have names or case numbers on it. It's just all random numbers. So I have to download everything, open it, and try to match it to the case it goes to. I did get some.
Chaos kicks off as Ryan Featherstone skips court again, claiming transportation issues. But the judge highlights a pattern of unpaid fines and missed appearances. This isn't just bad luck, it's becoming a habit. Will the court show leniency or crack down hard? Subscribe now for more intense courtroom drama and real legal breakdowns.
As good a time as any. Mr. Ryan James Featherstone has failed to appear on a trespass charge. File number is 251076. Defendant did contact his lawyer earlier and said he didn't have a ride. Well, this date didn't just sneak up on him. So I emailed Ms. Harden back and said, well, he needed to be here or he could be subject to a warrant. He has $2,360 worth of unpaid fines and costs, including larceny, attempted resisting, obstructing a police officer, 5, no proof of insurance, a previous trespass, and several unpaid booking fees. So he doesn't take any of this very seriously, and it's an inconvenient nuisance. He has a previous trespass from 2024 where he owed $150. He's paid none. As far as I can tell, he's paid none on any of these charges.
Your Honor, in speaking to Mr. Featherstone this morning, he advised he did have a ride lined up yesterday. When he went to confirm, he could not reach that individual. He said he even walked to her home to try to connect with her to ensure he had the ride, and she was not there. So he did. It sounded to me like he had the forethought to arrange transportation, but that fell through at the last minute, unfortunately. I do believe he's in a position where he's struggling with, housing and stability.
He is struggling.
I finally have a good phone number for him. I advised him of what the court had indicated. He was hopeful he could be awarded an adjournment. We've only had one hearing on this previously, but he did appear. So I would leave it at the court, but indicate that it's my understanding he did make efforts to get transportation and that fell through at the last minute.
We issued a bench warrant. Eddie, who failed to appear for the original pretrial on August 7th. So he didn't show up then, and we issued a bench warrant. Then he didn't show up on, that was August 1st. He did the same sort of thing. So then he got picked up on the bench warrant. So the answer is no. As I said, he's failed to appear, I believe, twice. He is struggling, but he keeps getting these charges and doesn't pay a penny and then doesn't show up when he's supposed to. So he knows the consequence of not appearing. This has been set for weeks. I've got generous donors that give me bus passes. So failed to appear for final pretrial. Bond is $2,360.40. I'll leave out the 40 cents. Cash or surety, 48-hour hold. Jordan, you and I will both be here tomorrow for attorney pretrials. If you can get him in here tomorrow, we can deal with it.
I advised him that the court would likely issue the bench warrant after 48 hours and encouraged him to appear tomorrow if possible, but I will give him another call after I'm done here today.
Is there a plea offer in this case? There's not much to do with a trespass case.
Yeah, this is the case where he's of the understanding or impression that he's already served his time on this.
Yes, he was adamant about that. And I tried to figure it out, and I don't believe he's correct.
No, I believe he thinks that because there was so much going on at the time of the last conviction that everything got kind of looped in. This was kind of on the court's radar. I think he thinks that even though there's not been a conviction, this case was taken into account of that. So, yeah, I've tried to explain that. And it's not sticking. So I will continue to talk to him. The offer from Mr. Stoll was to plead as charged, but with a recommendation for fines.
For fines that it won't pay.
Based on the court's representation today, I don't think that's probably.
All right, well, let's see if we can get him in here tomorrow. We've got time to deal with it. I went through, I have to do it again. I went through it carefully to see, and this case was not addressed.
Ms. Campfield looked, I looked.
I don't make the charges. I just tell them what they are. So, all right, let's see if he'll show up tomorrow. We can deal with it. Otherwise, I've set the bond in the amount of money that he owes the court for previous unpaid fines. All right, who's next?
I do have two pleas, Mr. Love. That's going to be set for trial, but I also have a motion pending before the court on that file. So,
all right, well, let's take care of Mr. Love, and then we'll take care of our other matters. Good afternoon. You're Jonathan Wayne Love?
Yes.
Mr. Love, we've discussed this case a couple of times. You're charged with domestic assault on your daughter. She's got one version and you got another version. Her version is you were drinking and your version is you weren't, which is this may have put the stops on your sobriety court. We were ready to bring you in until this happened. Now everything's kind of on hold. What's the status here, Ms. Hart?
thank you. The offer from the prosecutor is to plead to the domestic violence as charged. I know at the same time this was going on, he was dealing with a felony court case in which he has retained counsel. I asked him today how that case was progressing, and he just said he didn't go to jail. So I'm not sure if that case has.
Is that case done?
Yeah, it's a plea.
Have you been sentenced yet?
20.
All right. And as I said, we were discussing sobriety court
Wasn't offered.
because of this.
No, they decided that there wasn't any evidence related to. It had nothing to do with it. They just offered a plea.
All right. Well, it did have something to do with it because I'm the sobriety court guy. And so I don't know where this is headed. I was hoping it would be resolved.
Yeah.
All right. So set for sentence on March 20th.
Yes.
In fact, we aren't supposed to take people with assaultive charges into sobriety court. I've done it, but anyway, this bollocks that all up. I was in your corner till this happened, and then the pin got pulled on it. I think you could use it. So what are we doing with this case?
He rejects the offer and is asking the matter to be set for jury trial.
Now the focus shifts to Jonathan Love's case, and things get serious with potential video evidence. The judge zeroes in on footage that could confirm the alleged assault, making this more than conflicting stories. In court, evidence is everything. If that video delivers, it could decide everything. What do you think it shows?
All right, and Cadence, the complainant, she's got some issues too, but you've had a lot of discord in that household. And you are entitled to a jury trial where they have to convince 6 jurors beyond a reasonable doubt that you're guilty. So let me ask a few questions. Abigail, do we have any digital media, body camera, photograph? She has some videos that she shot.
There is body worn camera.
I'm not sure. I got some, unfortunately, the way that evidence is distributed now, it doesn't have names or case numbers on it. It's just all random numbers. So I have to download everything, open it, and try to match it to the case it goes to. I did get some emails today of digital evidence that I'm currently in the process of downloading. So I'm not sure if that's part of that. I don't know how often.
This happened in January. Well, according to the affidavit, Cadence was videotaping stuff going on. And there's some live video of her allegedly while this is going on. There's also photographs. So do you have that video? Do you have Cadence's video?
I'm not sure, Your Honor. I was-
Well, you should be. This is the last pretrial. That's obviously key evidence. Have you seen it?
Me?
Yes.
Yeah, I see it.
All right. So you saw it from Cadence, or you saw it from the officers, or you
So
saw
I
it
saw,
from?
I saw it from my attorney in the other matter.
All right.
Which I don't have any video, so I don't know if his attorney was able to get something I don't, or if I haven't gotten it yet. But like I said, I received some files today for digital download that I'm in the process of downloading, but they don't have names attached, so I have to go through and parcel it all.
Well, here's what the affidavit says. On the video footage, I observed Cadence recording the alcohol in the fridge, yelling at Jonathan that he's in sobriety court. I then observed Cadence walking toward Jonathan in his bedroom, telling him he is drinking a beer right now. Cadence then attempted to walk around Jonathan and take a video of the beer can on the dresser. While Cadence was attempting to walk around with him, Jonathan grabbed the back of her hair and pulled her down to the ground. This is apparently on video. Cadence was saying ow several times, and she was shoved out the bedroom door onto her back. Then she ran out of the residence. So that video footage is very important. It's the basis of a lot of the charge. All right. So, all right, we have Cadence. Love. Kevin Eder, police officer. Do you have any witnesses you wish to present? Who would you have?
Sweetwater. Love. Ricky Serdick, and then my mother, Sharon Love. Or Sweetwater and Sharon won't require a subpoena. They're definitely willing to come.
All right, very good.
Is the court requiring written witness lists?
Yes, a witness and exhibit list should be within 21 days. Mr. Love, we're going through some relocation. That's a polite way of saying they're tearing everything all up. So we aren't going to try any cases in April. So the very earliest this matter could be set would be May or possibly June. So stay in contact with your lawyer.
Your Honor, I do have a motion to withdraw.
Oh,
Pending.
Oh, yes, you did. That was filed a while ago. Where is it? Maybe I should have done that first. Notice of motion, which is today. Where's the motion? There it is.
This moment reveals a critical twist. Love is asking for court-appointed counsel while holding significant assets and already hiring a private attorney elsewhere. That raises serious credibility concerns. The judge sees through the inconsistency and questions eligibility. This isn't just legal strategy. It's about financial truth versus courtroom claims under scrutiny.
Your attorney has moved to withdraw because you've retained counsel in the other case, and you're asking for court-appointed counsel in this case, and you didn't fill out the income portion of the petition for court-appointed counsel.
I didn't receive one.
All right, are you employed?
Yeah.
Where do you work?
And Bristol at Rush Corps.
What's the name of it?
Rush Corps.
Rush Corps?
Been there for 3 years.
You're gonna lose your driver's license as a result of your plea in circuit court.
I lose the job to go with license.
So you're gonna lose your job?
Probably. It's a pretty far walk.
Yes, it is.
Your Honor, the basis for filing the motion in reviewing MCL 780.9913, there are factors that are considered by the court when utilizing indigent defense counsel. That would include property owned by defendant, economic interests, employment, things of that, and that the ability to retain an attorney would not create a substantial financial hardship. As indicated on his petition that he swore to and signed, he has assets exceeding $200,000. He's retained private counsel in another matter. I don't think he qualifies, or at the very least requires further investigation to see if he partially qualifies. But I don't truly believe that he's in a position where he could be considered injured by the court and entitled to court-appointed counsel. Just in review of his petition and the court rule. So,
Judge McManus, that's him on the right in the picture there. It's not a very good picture, but the picture's okay. I wish the painting were better, but I think that's the one he wanted. Said under the existing pre-contract, J. Paul Getty could have a court-appointed attorney. That dates us all. J. Paul Getty was one of the wealthiest men in the world in 1984. But we don't do any sort of indigency screening. Essentially, everybody that requests court-appointed counsel gets it. Occasionally, someone will file a motion to withdraw. Just because you have a house doesn't mean you have money. I'm familiar with your house. My aunt used to own it.
Just
What?
Yep.
And you're about to lose your job. You have a felony charge pending. You may end up at the Twin County Community Probation Center. And for the time being, I'm going to deny the motion to withdraw. If I get more information, I might consider it. But point of fact, nobody is making any determination of eligibility. When I was chief judge, I asked the county to fund a position to be the person that determined who was eligible, and they declined to do that. Subsequently, the Indigent Defense Act morphed and has changed, but I do believe the defendant's about to lose his employment. So the motion to withdraw is denied, subject to further review, circumstances change. All right, I'll set a jury date, probably in June.
When would you like written as an exhibit list filed, Your Honor?
Say that again?
Oh, no, mind. Within 21 days of today's date or
Yes,
trial?
of today's date.
Thank you.
And hopefully you could find that video. The defendant's seen it, his other lawyers.
Right.
You should have it. If it shows what it says it shows, that's pretty powerful evidence.
That doesn't.
All right, well, just because somebody wrote it down doesn't make it so.
It's true.
All right, well, we'll have a jury trial and see what the jurors think about it. All right, Mr. Lundy, you're good to go.
Thank you.
In the end, the judge denies the attorney's withdrawal, sets the case for jury trial, and emphasizes the importance of key video evidence. Love faces serious risk moving forward, while Featherstone deals with warrants and financial penalties. Every decision here carries weight. Like, comment, and subscribe for more powerful courtroom stories and breakdowns.